All right, let's begin. Good morning. My name is Elizabeth Kendall. I'm the Acting Assistant U.S. Trade Representative for Innovation and Intellectual Property. This is the public hearing for our annual Special 301 review. This review is a statutorily mandated exercise we undertake each year to develop an overall strategy to ensure adequate and effective intellectual property rights protection and equitable market access in foreign countries for U.S. persons that rely on protection of intellectual property rights, such as copyrights and related rights, trademarks, patents, trade secrets, and others. Ensuring that U.S. owners of intellectual property have a fair and full opportunity to use and profit from their intellectual property is one of the trade priorities outlined in the President's recently released trade agenda. This is the 30th annual Special 301 review and the 9th public hearing that USTR has hosted in connection with this review. For the record, I'd like to note today is Thursday, March 8th, 2018. This hearing is taking place at the Office of the U.S. Trade Representative. We will make a transcript of today's hearing available to the public on USTR's website. Today's hearing is scheduled to go till approximately 3 p.m., and we will break for 1 hour from 12:10 p.m. to 1:10 p.m. I would appreciate everyone's cooperation in keeping the hearing on track. At this point, I'd like to invite my colleagues on the panel to introduce themselves, starting with Labor.
Good morning. I'm Maureen Pettis, and I work for the Bureau of International Labor Affairs, Department of Labor.
Good morning. I'm Aurelia Schultz. I'm from the U.S. Copyright Office.
Juan Chang, Department of Treasury.
I'm Lisa Dyer from the Department of State's Office of Intellectual Property Enforcement.
Good morning. My name is Sang Chang. I am at the U.S. Trade Representative's Office, Office of Intellectual Property.
Stephen Mitchell, International Trade Administration's Office of Intellectual Property Rights in the Department of Commerce.
Good morning. Carrie Burdute from the Patent and Trademark Office, Office of Policy and International Affairs.
Hi, Emily Blymond, Department of Health and Human Services, Office of Global Affairs.
Good morning. My name is Omar Karawa from the Department of Department of Agriculture. Thank you.
Thank you very much. This is the Special 301 Subcommittee of the Trade Policy Staff Committee, which is comprised of the agencies you've just heard of, and the Department of Justice and a few others. This subcommittee is chaired by USTR, and we conduct the annual review. The review is based on public contributions, as well as the contributions of Washington-based agencies and our embassy-based personnel around the world. The subcommittee is currently in the information gathering phase. On behalf of the agencies here, we thank you for the insights and factual information you will share with us today. The schedule of today's hearing is comprised of interested parties, foreign government officials, private sector stakeholders, and stakeholders from civil society who responded to USTR's notice in the Federal Register published on December 27th and voluntarily requested the opportunity to appear at this hearing. As a reminder, the purpose of the hearing is to provide the Special 301 Committee with additional information that we can use in the deliberations that will result in the publication of the 2018 Special 301 report to Congress on or about April 30th, 2018. This year, we've received public filings that address over 75 countries and many country-specific IP protection and enforcement concerns that may negatively affect our bilateral trading relationships. These filings are available to the public at www.regulations.gov. Most of you may know that the Special 301 report is the result of the congressionally mandated annual review of the state of intellectual property rights protection and enforcement in trading partners around the world. The U.S. Conducts this review through the Office of the Trade Representative, pursuant to Section 182 of the Trade Act of 1974. The provisions of this section are commonly referred to as the Special 301 provisions of the Trade Act, which is where we get the name. Specifically, Section 182 of the Trade Act requires that the U.S. Trade Representative identify countries that deny adequate and effective protection of intellectual property rights or deny fair and equitable market access to U.S. persons who rely on intellectual property protection. This statute explicitly requires USTR to determine which, if any, countries should be identified as priority foreign countries. acts, policies, or practices that are the basis of a country's identification as a priority foreign country can be subject to the procedures set out in sections 301 through 308 of the Trade Act. In addition to the statutorily defined PFC designation, USTR created this priority watch list and watch list categories to assist the administration in pursuing the goals of the Special 301 provisions. USTR is also charged with developing priority watch list action plans where a country has been on the priority watch list without change for at least a year. The format of the hearing will be as follows. Each party has been allotted 10 minutes. That is comprised of 5 minutes of prepared statements, leaving approximately 5 minutes for questions. We will be watching the clock and provide a time cue when 1 minute remains from the allotted 5 minutes of prepared statements. The panel will hold its questions until the presenter concludes his or her statement. In general, please keep in mind the purpose of the hearing, which is to provide information that the committee can use in satisfying the charge of the Special 301 statute. We will break for 1 hour, as I mentioned, from 12:10 to 1:10 p.m. So at this time, I would like to invite the government of Bulgaria to start us off. Welcome. Please introduce yourself and begin your testimony.
Very good morning to you all. Ivo Konstantinov, Embassy of the Republic of Bulgaria to the United States of America, reporting to the Ministry of Economy, the presiding agency on IP enforcement in the Republic of Bulgaria. The name is spelled IVO, first name, last name KONSTANTINOV. I'm here to present the measures taken in the past year by the Bulgarian government and the government bodies and agencies responsible for IPA enforcement, as we treat seriously and are concerned with the inclusion of our country, 5th year in a row, in the watch list in the section Special 301 of the U.S. Commerce Act. We realize the gravity and importance of IPR enforcement, and our desire is to prove that we have taken sufficient measures to be taken out of that list, as we strive to be preferred investment and trade partners to U.S. businesses and the government. There's several government agencies that jointly execute IPR enforcement in our country. They are the Prosecutor's Office, the Ministry of Culture, the Patent Office of the Republic of Bulgaria, the Customs Agency, and the Ministry of Economy. It's our Department of Commerce. Together with the U.S. Embassy in our country and respective government agencies here in Washington, D.C., every year we receive a list of recommendations kindly provided by our U.S. Friends and partners. And the past year, those were mainly concentrated in 4 areas, which we have taken deliberate efforts to execute and apply according to the recommendations of our U.S. friends, mostly in the area of legal reforms, the specialized unit for computerized crime and intellectual property structure within the Ministry of the Interior, structuring of IPR specialized prosecution offices, not just in the capital city, but in the provinces and areas of the country, and various measures to improve the efficiency of the judiciary in dealing with IPR cases, imposing dissuasive sanctions on criminals in the field of IPR. Those were the U.S. recommendations to us last year, and we've done a lot to apply and take concrete, tangible steps in following them. Roughly a month ago, our parliament also adopted the new penal code of the country, which now incorporates a very practical, deliberate enforcement articles and procedures, particularly on IPR, where the penal code was more deficient years ago in its old structure. The prosecutor's office has filed a total number of 125 orders against 130 accused individuals. The total number of penalized individuals in the area of IPR infringement in the past year have been 139, including 1 conditional imprisonment of an IPR infringement individual, 1 probation. 137 individuals have been convicted for IPR-related crimes, 96 of them by a verdict decision in force from the previous year, 65 conditional imprisonments, 1 effective deprivation of liberty, it's a form of detainment, and 70 probations and 540 fines. That's the prosecutor's office. Ministry of Culture controls the observance of the Copyright and Related Rights Acts and checks the inspections of transmission and retransmission of TV programs, public performance of music are at different sites, unauthorized use of computer programs, and the Optical Disc Act. One of the most important and sensitive areas is certainly the fighting of software piracy, where we've been alleged as a leading breaching hub for Southeastern Europe, particularly in the downloading of entertainment content through torrent trackers. And in 2017, a number of successful actions have been taken against software piracy and illicit download of entertainment content. So fighting unregulated broadcasting as well of television programs included fighting of unregulated public performance of musical works, combating the unauthorized use of protected works on the internet, and at least 10 inspections were carried out. 1 mandatory injunction was issued to remove inconsistencies and violation of the law. Torrent tracking operators cooperate now with law enforcement, and with those that don't, some particular measures like constantly forcing them of migrating their sites to different servers in order to bleed out and lose users is done by law enforcement on the ground. So those are just some of the measures we've taken the past year, and we appeal to be taken out of the list, being confident that we have followed your friendly recommendations. Thank you.
Thank you very much for your testimony. The first question is from USTR.
Thank you again for your testimony. Bulgaria's written statement notes that there is a decline in piracy disseminated by internet providers in Bulgaria, and you've kindly, in your testimony, also mentioned 2017 improvements on software piracy and downloading of illicit content. Could you please tell us a bit more information about the basis of that statement in your written submission?
Certainly, there's 4 factors that contributed to that. One is that we have a stake ourselves now with growing local entertainment industry, with Hollywood movies being produced in our country on a massive scale, and Bulgarian software being developed already as a product and software as service locally. Some of it is also the availability of content affordability through the internationalization of Netflix, which was a significant move a year ago. And some is the migration of torrent tracking illicit download of entertainment content to streaming sites, which are outside of our country and outside of our region. Those were the contributing factors, but there's a significant decline in the most sensitive area where we are implicated usually, which is the illicit download of entertainment content and software. So the progress is really visible.
The next question will be from ITA on behalf of the Department of Justice.
Yes, we're particularly interested in the information you were able to provide on the efforts of the cybercrime sector in the cross-border organized crime department of the General Government of Bulgaria, or the General Directorate for Combating Organized Crime. My apologies. I hope you don't mind if I refer to it as the CDBOP.
Sure. I get what you mean. I know what you mean.
How will the government of Bulgaria ensure that the CDBOP has adequate resources for investigations of online piracy that then lead to effective prosecutions?
Their structure allows for it, as well as increased resources and budget, plus the constant regular trainings that we provide for them. And the trainings are something new that developed the past 2 years. But I will elaborate more in writing, if I might, to your question, which is excellent. And thank you for it.
Thank you. The next question is from the U.S. Copyright Office.
The 2017 Special 301 report noted concerns with gaps in Bulgaria's law with respect to the exclusive rights granted to rights holders in copyright enforcement online. You mentioned the new criminal law amendments, but could you please describe any additional legislative steps the government of Bulgaria has taken in the past year to address these concerns, including any bills or amendments that have been introduced in their current status?
We've described quite a few of them, which time would not allow me to list now. There's not just the penal code, but there's a comprehensive package of reform and legislation. Because obviously from the late 90s, the legislation indeed was obsolete to face especially new piracy practices. And I will provide a list of those additionally, if I might.
Thank you.
Thank you very much for your testimony, and those are all the questions we have today.
Thank you to the esteemed commission. Have a nice day.
Thank you. I'd like to invite the government of Ukraine to come up and speak. And please state your name for the record. Thanks.
Good afternoon. My name is Mikhailo Titarchuk. I'm Deputy Minister of Economic Development and Trade of Ukraine. On behalf of the Government of Ukraine and Ministry of Economic Development and Trade, I would like to inform you, first of all, it's really a serious issue, what we're going to discuss now, and I would like express my utmost respect to the Office of the United States Trade Representative and for others United States government institutions, to all participants. For the time being, Government of Ukraine approved action plan for the next 3 years, whereas IPR is one of the priority. So we're seriously considering about IPR in our country. So our work on IPR infringement issues has taken place on the following 5 areas. First, reform of the system of the state administration in the intellectual property rights sphere. Second, strengthen intellectual property rights enforcement. Third is IP protection, addressing piracy in the sphere of copyright and related rights. Fourth, legalization of software products installed at executive government bodies. And the last one is tackling patent issues in the sphere of collective management of property rights. In terms of strengthening intellectual property rights protection, reform on judicial system. In the framework of judicial system, a special IP court will be established in Ukraine. As recently in 2017, it was signed the special decree of creation IPR court by the President of Ukraine, Poroshenko. So we're expecting this year, and it's going to be 21 judges. In terms of draft laws on IP issues, so the government of Ukraine has already approved and submitted to the Parliament review for current session several draft bills on IP issues. First is patent trolling, industrial designs and trademarks, number 5699. Second is custom procedures regarding IPR protection, 4614. Then third one, geographical indication, 6023. Fourth, topography of semiconductor products. Then innovations and utility mode, 7538. Second one, copyright and related rights issues, 7539. And the most important is on efficient management of property rights of rights holders in copyright and related rights sphere, 7466. So the third point is collective management issue. So for the time being, is one of the biggest priority for us. So in terms of this, the government draft bill was prepared on the basis of recommendations of international experts involved into EU-funded twinning projects strengthening the protection and enforcement of intellectual property rights in Ukraine. The government draft law envisages function of limited number of organizations for providing with mandatory and extended collective management, and also it clearly differentiates the spheres, categories of property rights under which the mandatory and extended collective management is provided. It will allow avoiding the current chaotic situation in the sphere of collective and royalty by collective management organization for the use of copyright and related rights objects. So our task for 2018 is to introduce automatic system of distribution of royalty based as the Ukrainian Agency of Copyright and Related Rights, UACRR. Also, we are planning to transform the UACR into not state-owned organization. The amount of collected royalty in 2017 by UACR was about $2.3 million, and by other CMOs, its 19 organization, was about $1.9 million. Legalization of software products installed at executive government bodies. So our ministry has developed and forwarded to the involved executive authorities for the approval the draft resolution of the Cabinet of Ministers of Ukraine on improvement of software legalization and inventory procedures in Central Executive Authorities of Ukraine, which the proposal of Microsoft Ukraine company had been taken into account. In March 2018, this draft resolution will be adopted by the government of Ukraine, which will improve software inventory procedure for determination existing needs in legalization and introduce more current mechanism of financing for legalization activities, both through formation of separate budget requested of each executive body and through budget program of immediately on software legalization in all executive bodies. It will also permit to hold an inventory within several months with the purpose of determining real needs in software legalization. The last one, IPR enforcement. So the activities of the National Police of Ukraine, 2017, secured 141 criminal proceedings in the sphere of copyright and related rights, among which 109 proceedings were initiated following the materials by the staff of the Cyber Police Department. 25 persons were solved with charges. 28 criminal proceedings with charging documents were forwarded to the court. The amount of the compensated material losses constitutes about $91,000. Due to efficient cooperation with providers and rights holders, representatives of Cyber Police Department terminated activity of international recognized internet top pirates, online cinema fs.to, top 5 ranking of the European online cinemas. Also the activity of cut sharing sources ISEEHD.tv that rendered services on broadcasting of about 1,000 TV channels was determined. So also 2017 National Police of Ukraine secured 314 criminal proceedings based on criminal infringements related to IPR infringements, among which 127 criminal proceedings are related again to copyright-related rights infringements, 40 illegal distribution of discs for laser reading systems, 125 illegal use of signs for goods and services, and 22 infringements of industrial property rights. Also, the representative of National Police of Ukraine carry out activities aiming at fighting against illegal production, storage, packaging, and sale of the falsified plant protection agents, toxic substances, agrochemicals, pesticides, poisons, with illegal use of marketing goods and services. The activities of the State Fiscal Service. About 9,700 cases of custom clearance suspension on suspicious of IPR infringements were registered in 2017. The value on infringement items was about $407,000. The activities of the State Service of Ukraine on medicines and drugs control. 2017, a State Service issued 106 orders on interdiction of turnover of 426 titles of low quality, falsified and registered medicines. And recently, the Council of Intellectual Property was established 7th of February 2018 with the purpose of coordination and interaction of the state and municipal authorities, law enforcement, supervisory agencies, enterprises, organizations, and establishing the IP sphere. The main task of the Council are strengthening IPR enforcement, fighting against internet piracy, patent trolling, software legalization, development of legislation, interaction with the High IPR Court. Thank you very much. Let me know if you have any questions. Thank you.
Thank you very much for your testimony. The first question will come from USTR.
Thank you for your explanation of your work on collective management organizations. What is the anticipated timing of the next steps that you just talked about, including in 2018 and beyond? Thank you.
Sorry, the last was?
Your work on CMOs, collective management organizations, if we could have a better idea of the timing.
Yeah, okay. Actually, recently on the 1st of March, the first reading we passed in the Parliament. We got 244 votes. And we're expecting actually to provide the final draft bill for the second reading. It should be end of March, so I'm expecting the first or second week of April, so to put in the whole of the Parliament for second reading. So if everything goes smoothly, we still have time to be approved until 26th of April.
Thank you very much. The next question is from the USPTO.
Thank you. I have a question regarding the on-state support of cinematography law that was passed last year. Could you tell us more about that law and how it's been implemented?
Okay, as you know, in 2017, that law was finally approved after long debates. For the time being, it was quite useful for our cyber police department, as it allows them to use it more practically, and especially one serious article was it's fighting against anti-piracy. For the time being, what I've seen, that also inside the cinemas there is a special software, it calls Camcord, which allows to identify immediately if there is something wrong inside. Plus, what we got from the state cinema agency is that there is no evidence for the last year, and also what is good, there is association which calls like anti-piracy cinema association in Ukraine, and they also motivated people who is employees inside the cinemas, if they see the evidence, to inform, and then they get then after that they get benefits.
Thank you very much. The final question is from the U.S. Copyright Office.
Good morning. Thank you for explaining so much about the software legalization process. In your view, what are the remaining challenges?
Challenges everywhere. For the last 20, because I'm deputy minister for the last year, and actually you have to start from everything from the beginning. So the long journey starts from the first step. Actually, the priority is now to really to fix collective management organization. Second, legalization software, which is very important, and I would like that my minister will show an example to other ministers. And the third challenge is, I think we need to increase more law enforcement in terms of, people who is trying not to respect intellectual property. So it must be more cases. And I think the final stage for our reform is creating IPR code. This is very important. Thank you.
Thank you very much for your time. I'd now like to invite the representative for the App Association to come forward. And please state your name for the record.
Good morning. My name is Morgan Reed, and I'm the president of the App Association. First of all, thank you all for this opportunity to testify. I'm happy to contribute our views on where the current state of play is with regards to trade, and also to focus a little bit on the intellectual property issues that we're all here to discuss. A quick level set, we have more than 5,000 member companies around the world, most of whom are in the United States, but are truly global. Many of our companies are as small as one person, but if there is one characteristic that plays throughout this, they are all global. The smallest members amongst us are just as global as the large. The ability of platforms to put applications in the hands of people in literally every continent in the world has meant that global reach for small business is truly here today. Our members drive about $143 billion app economy right now. More than $8 trillion of money flows through the mobile ecosystem today through goods and purchases from manufacturing to daily life. And they are also critical to workplace productivity and health. In that instance, a huge part of what makes this possible is the fact that data can flow freely and unfettered, and that people can be fairly compensated for their work. We look at our key areas in the trade space as kind of a fairly straightforward flow tree. We start with the problems we have in the trade space around limiting cross-border data flows, data localization policies in countries around the world, custom duties on digital content, requirements to provide source code for market entry, requirements for backdoors and encryption technique, and of course the thing we're here to talk about, intellectual property violations. One way to understand IPR violations for a small business is that unlike larger businesses, IP violations can be end of life for a small or a new company. we don't have the cash flow to bear a large impact event with IP. It also, IP violations often are concomitant with data loss, revenue loss, and reputational damage. So IP is not just something that happens and can be brushed under the carpet. It's critical for the way that we do it. We see these violations occur in numbers of ways. First, we have piracy that exists by replication of an application where the digital rights management component is reviewed. Content for an app will be repurposed elsewhere, changing advertising keys to redirect ad revenue from a legitimate business, or injecting malicious code that collect users' private information. And I want to take a moment and give an illustration. One of the things that everyone on this panel has heard over the years in the IPR space is this idea of, well, you have the wrong business model. So I'm going to tell you a story about how business model doesn't necessarily matter. One of our members has an application that was global in use, small company, about 5 people. It was a free application, free, ad supported. So you'd say, well, it's free, it should have no problem with piracy. Incorrect. What we found from what happened to him from overseas piracy was they took the content off the top of his application, put a new ad network underneath it, laid it down, changed the name, and put it into the App Store. So his literal free app was competing with someone else who had added a new ad network with his exact content. And here's the double stinger. Because a lot of his content was video, he was still paying the streaming costs for the free version of his app that was stolen with another ad network. So not only was he not seeing the revenue from advertising, he was paying the cost for the stolen pirated app to exist. And so when we talk about business models and IP, think of it more largely than we have a business model problem. No, we have a law enforcement problem. We figure that the loss to app developers and publishers runs between $3 and $4 billion a year due to the use of pirated apps. And we do see where foreign regulators will use regulations or fail to enforce protections that facilitate IPR infringement. Notably, we are concerned with countries that do joint venture requirements or foreign equity limitations, source code escrowing, and market access requirements that really force our members to transfer intellectual property. So you have straight piracy on one hand, and then you have the other aspect of piracy, which is not piracy, where you have a regulatory structure that really encourages our members to divest themselves of their IP in order to play in a market. And so the special 301 report is really critical to our members, and I think one of the aspects that you should recall as you go through this process is it is completely relevant to the smallest and the largest companies in the United States, and what we have shown from our studies is it is not regional in terms of its impact in the U.S. So we encourage your efforts to go forward and to think about the small business impact as well. Thank you.
Thank you very much for your testimony. The first question will be from USTR.
Thank you very much for your participation in this year's 301 review. I understand it's the first time that you've submitted comments to the review.
That is correct.
And participation of diverse stakeholders greatly improves the process, so thank you very much. In your written submission, you note that app developers and publishers lose an estimated $3 to $4 billion annually due to more than 14 billion pirated apps. Does the ATC have estimates or other information about which foreign countries those damages in pirated apps are coming from?
We do have some estimates, and you can see from our written testimony where we talk about specific countries and where we've seen the impact. The difficult part of it is, again, because if an application is side-loaded into a mobile device, we have no idea on how much usage there is. We have anecdotal evidence, but hard numbers are really hard to come by, mostly through the way that the applications move through the ecosystem.
Thank you. The next question comes from the U.S. Patent and Trademark Office.
Thank you, Elizabeth. ACT submission notes certain positive steps that the government of India has undertaken to help improve the protection, enforcement, and administration of IP rights in India, but you're recommending PWL status because the country still needs to create an adequate IPR system and implement strong enforcement, and that's a quote. Could you please describe any specific challenges in India that continue to negatively affect your members?
I think that given the length of time we have here, that's preferable to give in a written comment, but I would say that it's always a battle. Everyone on this panel knows you want to encourage the good acts that help this move forward, but without some pressure, it's very hard to keep those going. I'd be happy to provide you a written response in longer term, but I'm aware of our time.
Thank you very much. Our final question is from the U.S. Copyright Office.
Morning. Your submission notes that Algeria has enacted key statutes to prevent piracy, but it hasn't made any meaningful attempts to enforce the statutes. Could you tell us more about what kind of statutes these are, and can you explain how the statutes would work to prevent piracy, and which aspects of enforcement of those statutes are lacking?
I am not our office's Algeria expert, but and I'm happy to have. So I'll be careful to make sure I don't say anything that our Algeria expert will come at me and say I got it wrong. But in rough reality, it's that Algeria appears to have statutes that should, if they were enforced, actually do the kinds of things we're discussing today. And so, as everyone in the Copyright Office is aware, it's this de facto versus de jure problem. And my understanding is from our person who's worked in Algeria on these issues, the de facto is so distant from the de jure that it makes it very hard. When we have meetings with authorities in Algeria, they say, the laws are on the books, what's your problem? And then the discussion is, well, but we're not seeing any action. We're still seeing rampant piracy, and our folks can see from IP addresses that their mobile applications are in use, but they can't figure out how many. So I will be happy to give you more specifics on the record if you'd like them, but it's a de facto versus de jure situation with Algeria.
Thank you once again for your testimony. Could the representatives from Alliance for Fair Trade with India come forward? And please state your name for the record.
Yep. Good morning, I'm Roger Murray, and I am the Deputy Director of the Alliance for Fair Trade with India, or AFTI. We are a diverse group of organizations that support increased action to address the multitude of barriers to trade and investment that U.S. companies face in India, including those adversely impacted by India's intellectual policies and practices. AFTI was launched in 2013 to support increased action to address the barriers to trade and investment that U.S. companies are facing in India, including the erosion of intellectual property rights, and to serve as a mechanism for engaging with U.S. policymakers on these issues. In light of this mandate, I'm here to request that USTR again place India on its priority watch list. As AFTI describes in detail in its written submission, India has not made sufficient reforms to protect IPR holders' interests with respect to patents, copyrights, trade secrets, and price controls, and continues to deny fair and equitable market access to U.S. entities who rely on IPR in myriad ways. Before summarizing our concerns, it is important to note that the government of India took 4 noteworthy steps in 2017 to bolster patent and copyright protections. First, it began a new national awareness campaign on the harms associated with counterfeiting and piracy. It made notable progress to reduce long-standing delays in patent and trademark examinations by expediting the patent approval process and increasing examiner capacity. Third, it announced revised guidelines to provide patent protections to computer-related inventions. And fourth, high courts in Delhi and Bombay provided content creators injunctive relief against pirated content, and the Department of Telecommunications helped carry out these orders. We commend each of these actions, but we want to state today very clearly that India must do much more. The government of India did not address critical and long-standing shortcomings to its IPR regime, identified in the 2017 and prior Special 301 reports, and took several new actions that created significant new intellectual property challenges. Of note, we highlight 5 critical shortcomings. First, costly and time-consuming patent opposition hurdles for patent applicants and long timelines for receiving patents. Second, the lack of an effective system for protecting data generated to obtain marketing approval. Third, major hurdles to patent protections for innovative medicines, such as measures in Indian law that add a legally questionable additional criterion for the patentability of medicines, and the possible use of compulsory licensing and patent revocation. Fourth, pressure to localize manufacturing for industries as diverse as information and communications technologies, medical devices, solar energy equipment, and capital goods. And fifth, price controls in the fields of medical devices, pharmaceuticals, and agricultural biotechnology that deny fair and equitable market access against U.S. products with valuable intellectual property. AFTI continues to track implementation of the Government of India's 2016 National Intellectual Property Rights Policy. The Government of India needs to act swiftly to translate those concepts in the policy that support IPR into concrete policy measures, but also must revise areas of the policy that promote forced localization, compulsory licenses, or otherwise fall short of India's international obligations. Finally, AFTI encourages USTR and other members of the subcommittee to engage with India throughout 2018, including through the Special 301 process and the Trade Policy Forum. AFTI continues to believe that together our governments can advance strong intellectual property rights that promote innovation, trade, and investment. So in closing, I want to thank the subcommittee for its tireless work to improve intellectual property rights of Americans, and I'm happy to answer any questions you might have.
Thank you very much for your testimony. The first question will be from USTR.
Thank you again. AFTI raises concerns with India's draft National Pharmaceutical Policy, the NPP, 2017, including in the areas of compulsory licensing and pricing policies. Can you please provide more details on the draft NPP, including whether there are other concerns and when India may finalize this policy? Thank you.
I do not have any information today on when we expect India to finalize the policy. I think as it relates to compulsory licensing, the threat is often as economically impactful as the action, and that the draft policy includes the threat of compulsory licensing, and that is a big signal to the industries that in the United States that of what's coming down the pipeline.
Thank you. The next question will be from ITA.
Yes, this question concerns multilateral dynamics. AFTI has called attention to India's intervening in international multilateral fora to advance the adoption of IP policies that run counter to robust protection and enforcement of IP. Could you describe what effect these actions have on how your members perceive India as a place to do business?
Well, I think our members operate and sell into multiple markets, so they engage with governments around the world, including in Geneva and elsewhere at WIPO. And it's really important that the United States work with governments from around the world to protect market access of products that depend on intellectual property. And so the signals that India sends, both behind closed doors and publicly in those forums, are immensely concerning and remain one of the critical issues that AFTI works on to educate both our U.S. representatives in Geneva and also representatives from other countries. And it's just immensely concerning to us.
Thank you very much. Our final question is from the Department of State.
Thank you for appearing today. You mentioned a bright spot as an improvement in copyrights. Certainly Hollywood and Bollywood share a concern about piracy. We wondered if you had any updates on the anti-camcording law. It's been waiting around for 15 years before it's been passed, and wondered if you had any updates and any insight into what's taken so long for this to move through the system in India.
Yeah, I wish I did have an update. It's been one of the initial issues that AFTI has concentrated on since our founding, and since the initiation of the Trade Policy Forum back in 2014. It's been high on the list for our government as a way for both Hollywood and Bollywood to thrive together in the Indian market. And unfortunately, we're not optimistic that there'll be progress in the short term. But this is also an opportunity to think or to look towards other ways to enforce and provide intellectual property rights, and the actions of the high courts in Delhi and Bombay, injunctive relief. It's just incredibly, it's critical, and somewhere that we think there's an opportunity for progress in 2018 as you all engage with your Indian counterparts.
Thank you once again for your participation.
Thanks for having me.
Could the representatives from American Apparel and Footwear Association please step forward? And please state your name for the record.
My name is Christina Metropolis, and I am a government relations representative at the American Apparel and Footwear Association. AAFA appreciates the opportunity to testify before the Special 301 Committee today. AAFA is the national trade association representing apparel, footwear, travel goods, and other sewn products companies and their suppliers which compete in the global market. We represent more than 1,000 world-famous name brands, their management and shareholders, our industry's nearly 4 million U.S. workers, and its contribution of $384 billion in annual U.S. retail sales. Counterfeiting of our members' brands remains a top concern. Footwear, apparel, and other fashion items top virtually every list of top counterfeited products and seizures. Our members' competitiveness is highly dependent on the protection of the intellectual property embedded in their designs, their brands, and their images. Stolen intellectual property costs our members billions of dollars in lost sales, damages their reputation, and results in substantial legal expenses. This morning, I would like to focus my testimony on 3 countries: China, Canada, and Mexico. Last year, the USTR placed China on its priority watch list. While our members report intellectual property improvements, China remains a source of pervasive counterfeiting. Actions to enforce intellectual property remain complex and expensive. As we have previously mentioned, we believe the U.S. government should work with Chinese customs to prevent counterfeit goods from leaving China, especially in cases in which the legitimate versions of the product are not manufactured in China. As the administration pursues its Section 301 investigation, we urge that it proceeds cautiously. While we agree that there are significant intellectual property concerns in China, we also stress that China remains an invaluable trading partner for our members and for our industry. For this reason, I want to be clear that we do not believe tariffs are a solution to this issue. China remains an important and growing market for U.S. exported and U.S. branded goods. For example, China remains a top market for U.S. exports of cotton and is a fast-growing market for U.S. branded goods that are made globally and sold in China. Many U.S. jobs are supported through these trade and investment links too. Steps to address Chinese intellectual property practices must be taken to ensure that these supply chains and the U.S. jobs that support them are not interrupted by U.S. actions or Chinese retaliation. Turning to Canada and Mexico, the USTR placed both countries on its 2017 watch list. Over the past year, our members report there is little clarity on the Canadian customs recordation system and that it has not been effective since it launched. One member reported its brand has registered with customs, but it has not actually seen any seizures. Members report that the Royal Canadian Mounted Police is inactive related to trademark and counterfeiting matters. Members report their local lawyers and investigators in Mexico have developed good relationships with regional police, customs, and the Mexican Institute of Industrial Property. Regional police have supported many raids for our members. Customs has increased working with members largely because of members' training efforts. However, corruption remains a concern when doing work in Mexico. Additionally, members report parasite brands are prevalent. Parasite brands look and feel like a counterfeit, but they do not directly call themselves by the brand name. In fact, the average consumer might be hard-pressed to notice a difference outside of the single distinction. Moreover, members note the upcoming elections will see changes at the head of Customs, the Office of the General Prosecutor, and the Mexican Institute of Industrial Property, which they are worried could quickly reverse course on progress. While we recognize that there are significant intellectual property concerns in these countries, we also want to make it clear that we are supporters of NAFTA. During the past 24 years, our members have developed extensive supply chains that today account for millions of dollars of U.S. textile, apparel, and footwear exports and imports to NAFTA countries, directly and indirectly supporting millions of jobs in the United States and benefiting communities and consumers throughout the United States, from Maine to Miami to Monterey. As we continue to engage in negotiations to modernize NAFTA, it is critical to strengthen the intellectual property provisions to address these issues. We appreciate this opportunity to raise these concerns, and we look forward to working with the USTR to address these issues. We consider this to be an ongoing process, and we will provide you with updated information as our members bring them to our attention. I will now take any questions you might have. Thank you.
Thank you very much for your testimony. The first question is from USTR.
Thanks again for your testimony. Some countries have been identified for several years in the Special 301 report for trademark or counterfeiting issues, but may not necessarily be the largest or most important markets to your members. Are there any countries that you think should no longer be listed in the Special 301 report for the issues that are most important to your members? Thanks.
So this year we identified both the successes and the challenges that our members have pointed out to us. And while we recognize that we didn't take a definitive stance on which countries should be listed, we wanted to leave that ultimate determination up to you, but we wanted to highlight while there are successes in certain countries, those come with challenges. So we thought that that was important to highlight.
Thank you. The next question comes from the Department of Labor.
Good morning. Your organization reports that there has been an increase in counterfeits in India, typically requiring extensive actions by the brands to resolve. Could you please describe in more detail the counterfeiting activity, trends, and challenges facing the brand owners?
So a number of our members have worked in India, and they're finding counterfeits not only in marketplaces but on e-commerce platforms in China. I'm happy to follow up with written comments on those specifics.
Okay.
Thank you. Our next question comes from Treasury.
For Turkey, AAFA reports that changes in customs laws now make it difficult and expensive to seize outbound goods, forcing member brands to file motions before the courts. Could you please explain in more detail the changes in the customs law and the negative effects on IP enforcement that resulted from this in Turkey?
So I'm happy to follow up with written comments on that. One of our members identified that for us. I don't know that much about it, but I can certainly follow up with you once I get more information from that member.
Okay, thank you.
Thank you. The next question comes from ITA.
Thank you. Regarding your observations concerning parasite brands, have any of your members had partial success in combating this problem? Do you see this as a question of trade dress or something else?
So, like I said, parasite brands, it's not a specific counterfeiting issue per se, but a number of our members have had successes in China, particularly one brand brought an action in court and received the largest judgment to date concerning parasite brands. So that was definitely a success on their part, and hopefully they'll continue to succeed. And as we noted in our comments, we also have seen parasite brands popping up in Mexico. So it remains to be seen what will happen with that.
Thank you.
Thank you very much, and thank you for your testimony.
Thank you.